Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about non-lawyers assisting in court matters. Cases that should have gone to the Supreme Court of Canada, but didn't. Veli Janvier was charged, along with his wife, with a number of tax-related offenses after an audit. During the course of the trial, he was assisted by a non-lawyer who helped him to represent himself, helped him to prepare submissions, and assisted him while actively in court. One of the issues that was raised at trial was the role that the participation of the non-lawyer played in the fairness of the trial process. And the question that was raised before the Supreme Court of Canada was, to what extent does the participation of a non-lawyer individual require or otherwise permit appellate courts or superior courts to exercise their function to control their process by issuing sanctions or by stopping individuals who are non-lawyers from participating in the proceedings? And we've seen a significant increase because of the complexity of litigation in Canada, the lack of available resources, and widening gaps in access to justice in circumstances where people rely on the assistance of non-lawyers, often to their detriment, in court, or who rely on non-lawyer assistance in preparing their documents, again, often to their detriment. And if trial fairness is compromised by this, in a system where the state is initiating a prosecution, and in a system where the state has every resource available to it to hire as many lawyers as they want, where state-funded legal aid systems don't necessarily cover all of the instances in which a government can compel a person to come to court, what is a court to do to ensure the integrity of the trial and the fairness of the process, particularly where there is evidence that a non-lawyer is involved in the preparation or representation of materials before the court, and where that non-lawyer may be compromising the rights of an individual at trial through taking a tactic that isn't going to be successful? To what extent does a judge's duty to assist a self-represented individual end at the point at which they have somebody assisting them that's not a lawyer? And to what extent does that duty that a judge has to a self-represented individual also include stopping something that is clearly generating an unfairness, although perhaps not an unfairness in the true sense of trial unfairness as we've come to understand it? These were important issues that were raised by this case, because the more people that are self-represented in our courts and the more people that are tempted to get non-lawyer assistance makes it necessary for courts to step in, like the Supreme Court of Canada, and to say, these are things that we can permit, and these are the steps that judges have to take to ensure that people aren't being taken advantage of. This is an important issue, and hopefully the Supreme Court of Canada will have the opportunity to correct some of what is clearly an injustice related to access to justice issues in this country in the future. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.